Right, good morning to my wonderful Year 2 A-level students. I hope you're having a fantastic Easter break so far. The sun's out, it's lovely and warm at the moment, and all very quiet where I am at the moment. So anyway, so the topic for today is remedies. It's based on chapter 24 of the AQA Year 2 textbook. So let's start off by quickly defining what a remedy is. A remedy is simply a solution to a problem. The main aim of a remedy is to put the injured party back into the position they would have been in if the contract had not been breached. Now, adding on to that, there are three main types of remedies. There are legal remedies, so if a contract is broken, then the other party is entitled to compensation or a suitable remedy. The second type of remedy is an equitable remedy. The word equitable comes from equity, fairness, and therefore typical examples of equitable remedies will be specific performance. For example, if you purchase a house and you're gazumped, in other words, the seller decides to sell to somebody else other than yourself, then you would go to court and seek the order of specific performance, which simply forces the seller to sell to you as previously agreed. Another example of an equitable remedy will be quantum merit, which simply means as much as they deserve. So if you are in a contract to build 10 houses and the contract is broken and you've only built 5 at the time, then your compensation is the other 5 that you were yet to build, and so on. Now, the final type of remedy is statute-based remedies. And if you remember the topic on frustration, then the Law Reform Frustrated Contract Act 1943 offers suitable remedy where the contract is genuinely frustrated. Now, the next thing to identify is the different types of damages available. So you have nominal damages, and this is where you receive compensation, as it were, in name only. So the court acknowledged that you were right to bring your case, but the amount of damages you get is exemplary. So you probably get £1 and that sort of thing. And then you've also got speculative damages where the courts have to roughly estimate how much you are entitled to. So it depends on the circumstances. They then have to work out a suitable remedy. Now, in all cases of remedies or compensation, remoteness of damages is very important. So in other words, did your loss directly result from the breach of contract? And the courts would have to look into that to decide whether that was the case or not. So read cases such as Hadley and Baxendale, Victoria Laundry, and so on. They are all suitable cases based on remoteness of damages. Right, the next thing to think about is responsibility to mitigate your losses, and that's very important indeed. So if you are going to claim compensation, then you must make sure that you do everything within your power to minimize the loss to the other party. So if you're going to claim compensation, the courts want to see that you've attempted to minimize your loss. So if, for example, you order 10 bags of sugar, it's not delivered, then the courts would expect that you find somewhere else to buy the 10 bags of sugar. And then after that, you may sue for compensation. Now, the other thing to appreciate is the fact that sometimes the contracting parties may include what we call a liquidated damage clause in the contract. The aim of a liquidated damage clause is to help the courts identify specifically how much compensation should be awarded. So, for example, if I contract with another party to sell them 10 bags of cement, we might agree to put in the contract that if either party breaches the contract, they would pay £10. Now, that's a typical example of a liquidated damage clause. It's a sensible amount. We both agree to that amount, and therefore, if the contract is broken, the courts just look at that clause and identify the amount of compensation that should be paid out. Now, another point to note is that the courts don't accept penalty clauses, and a penalty clause is simply where one party includes an extravagant amount of money. So in the example I gave before, if we contract to buy or sell 10 bags of cement, and I include in the contract that if the contract is broken, you would have to pay £1 million, then that's very disproportionate to the actual contract. If, for example, the contract only is worth £10,000. So that's a penalty clause, and the courts will not allow that. And the final thing that one party might have is a lien, which is, for example, if I take my car to a garage to be fixed, and I decide not to pay for it, then the garage owner has the right to keep a hold of the car until payment is made. So as a quick summary, and as I always keep an eye on the time, I don't want to go over 5 minutes, so as a quick summary, please remember that remedies are an integral part of answering an exam question on contract law. It's important that you remember the different types of remedies and how important it is to mitigate your loss. Also bear in mind, did the loss flow from the breach of contract? And that's to do with remoteness of damages. Right, so that's a quick summary of chapter 24. Have a great rest of the day. I shall see you all tomorrow, and as you can tell, I'm heading into this wonderful sunrise, yeah, enjoy the rest of your day, and I'll see you tomorrow. Take care.